Welcome to CM Guide's Deep Dive series. Today we're plunging into something that is, well, truly the engine room of one of New Zealand's most vital industries. We're talking construction contracts, statutory adjudication, and the critical security of payment legislation. Now, this isn't just a topic for those, wearing hard hats or poring over blueprints. It holds profound practical relevance for anyone involved in, or even just interacting with, the construction sector. And it also offers a really fascinating glimpse into how large-scale projects are legally managed and sustained right across the country. Our mission today is pretty straightforward: to unpack the New Zealand Construction Contracts Act 2002, often just called the CCA, and its related legislation. We'll try to simplify its complex mechanisms, explore its compelling history, demystify how it actually works on the ground, and look at its real-world impact. Joining me to navigate these frankly intricate waters and connect all the crucial dots is an expert who can synthesize diverse information into clear, actionable insights.
Yeah, thanks. And what's truly fascinating here is the sheer transformative power this legislation actually wielded. It fundamentally reshaped how payments and disputes are handled in construction. It was a dramatic shift from what used to be a notoriously long, drawn-out, and often, well, financially crippling process to a much more immediate and decisive pay now, argue later approach. And this principle, it isn't just a legal nicety, it's the very heartbeat of the Act. It represents a huge paradigm shift for the industry.
Pay now, argue later. That sounds quite forceful.
It is. Historically, the construction sector was plagued by severe cash flow problems, often because unscrupulous parties deliberately delayed payments. They might leverage even minor issues, perceived defects, as an excuse to withhold crucial funds, which effectively strangled contractors and subcontractors. It was a major issue. The CCA was explicitly designed to put an end to this. Its core purpose was to establish strict procedures and swift dispute resolution mechanisms, all to ensure money kept flowing and, crucially, that projects kept moving forward.
Right, keeping the wheels turning.
Exactly. So as we journey through this deep dive, we'll trace the Act's development, we'll dissect the mechanics of payment claims and adjudication. We'll understand how our courts oversee and enforce this system, and finally, look ahead to what the future might hold for these vital regulations. It's quite a story, from past crises to, well, ongoing challenges.
Okay, let's unpack this then. At its very core, what was the Construction Contracts Act really designed to achieve? And why is that pay now, argue later principle so absolutely crucial to how it works? What was the big problem it was trying to fix with such a unique approach?
Well, at its essence, the CCA's primary focus is laser-sharp, establishing a clear, strictly enforceable payment procedure. Think of it like creating a vital circulatory system for money within a construction project, setting up specific step-by-step processes to ensure payments are regular and, most importantly, timely.
Okay, so it's about the flow of money.
Precisely. And what makes it so powerful is that it outlines very clear, often immediate consequences for both adhering to and failing to adhere to these procedures. We're not just talking about minor penalties here. There can be what are often described as sudden death outcomes for parties who simply don't follow the rules.
Sudden death, that sounds serious.
It can be. Alongside this payment framework, a secondary but equally critical objective is the rapid resolution of disputes. The Act deliberately designs processes to bypass those immediate drawn-out arguments over things like claims of poor workmanship, because those kinds of issues in the past were so frequently exploited by principals, the ones paying or head contractors, as a tactic, really, to deliberately delay payments. And that practice was incredibly damaging to the industry's lifeblood, its cash flow.
So if a principal or head contractor tries to, play games or use delaying tactics, the Act steps in quickly to stop that derailing the project.
Exactly. The pay now, argue later principle is the absolute bedrock of the entire Act. What this means in practice is, if a principal or any payer fails to follow the correct procedure, say, by neglecting to issue a proper response to a payment claim within the time frame, they might find themselves legally obligated to pay the claimed amount in the interim. And that's regardless of whether they genuinely believe that claim is fully merited or accurate.
Wow, okay. So the burden shifts completely.
It does. This regime isn't accidental. It intentionally shifts the burden of any potential cash flow delay. If a principal or payer doesn't act swiftly and strictly according to the Act's procedures, they are the ones who bear the financial consequences of that delay, not the contractor or the subcontractors who've already done the work. This directly addresses that long-recognized truth that consistent cash flow isn't just important, It is often described in industry commentaries, the very lifeblood of the building trade. Without it, projects grind to a halt, businesses face bankruptcy, and livelihoods are lost. The industry just can't function effectively.
That paints a vivid picture of urgency. But you mentioned an adjudicator's decision is binding but interim. That sounds a bit like a paradox. What does that actually mean, practically speaking?
Yeah, it's a crucial distinction and maybe one of the most powerful points of the Act. While an adjudicator's determination is indeed binding on the parties, for now meaning the money awarded must be paid, it's not necessarily the final word on the underlying dispute itself.
Okay, so the money changes hands, but the argument might not be over.
That's right. The dispute itself can still be formally determined later in a different forum, like arbitration or even a high court proceeding. Think of it like a temporary but enforceable ruling in a sports game. The play has to continue, scores get updated based on that interim decision, but a deeper, more time-consuming review of a complex rule interpretation might still be pending.
I see, so it keeps things moving.
Exactly. This dual nature ensures work continues, and parties get paid for the work they've done, even while deeper, more protracted arguments over the ultimate merits, or the final figures, are still being thrashed out in a more time-consuming legal forum. It's about separating the immediate cash flow imperative from the ultimate resolution of those complex contractual arguments. The goal is cash flow, keeping the project moving, preventing financial devastation.
Here's where it gets really interesting for me. Legislation like this doesn't just appear out of thin air. What was the driving force? What was actually happening in New Zealand's construction industry that made the CCA so necessary? It sounds like there's a real crisis.
Oh, absolutely. You've hit on it. It wasn't just a crisis. It was a devastating series of financial collapses that created an undeniable, urgent need for this legislation. The act was passed in 2002 against a very stark backdrop of significant, high-profile failures in the NZ construction industry. To give you some historical perspective, think about the shockwaves from the collapse of the Auckland-based construction company JBL back in 1988.
JBL, I remember that name. That was huge, wasn't it?
It was massive. JBL had offices in Australia, Japan. They were even looking at London. When it imploded, over 3,000 investors lost money. And more than 2,000 creditors, many of them subcontractors, suffered catastrophic losses. One of the founding brothers even went to prison. And while the initial perception might have been, went too far too fast, the real reasons, a dire lack of working capital and poor management. Well, those are issues that unfortunately still define many corporate failures today.
That sounds like a monumental failure, a real wake-up call. Were there others like that? Did it keep happening?
Sadly, yes. Fast forward to 2001, just before the CCA was enacted. Another family company, Harder Construction, collapsed. It left behind debts over $30 million. And again, the vast majority owed to unsecured creditors, overwhelmingly subcontractors.
Right. The smaller guys at the bottom of the chain always seem to get hit hardest.
Exactly. And this tragic pattern was then echoed, even more dramatically 12 years later, by the huge Mainzeal property and construction collapse in 2013. That left a staggering $130 million owing, again, largely to unsecured subcontractors. These cases weren't just headlines. They vividly illustrated the extreme vulnerability of subcontractors. They were, in essence, forced to partly finance major construction projects because of chronically delayed payments from head contractors. Their businesses failed. Jobs were lost when these head contractors collapsed, often because the big payments they got from owners were either diverted or just withheld from those further down the chain. This exact vulnerability was a central issue identified and debated even when the Construction Contracts Bill was first introduced in 2001. It was clear the system was broken.
So before the CCA, what were the practical challenges contractors faced every day that left them so exposed? What protections were missing?
Well, prior to the CCA, contractors operated in an incredibly precarious environment. Firstly, there was simply no common law right to progress payments. This meant any interim payments were essentially paid on account, almost like an advance until the final completion was certified.
So you could be working for months without guaranteed payment.
Pretty much. Imagine pouring months of resources and labor into a project with no guaranteed interim payments. Immense strain. Secondly, there was no real security for those interim invoices. Court cases had established that owners could pretty freely make deductions from payment claims, leaving contractors and their whole supply chain incredibly vulnerable. It squeezed cash flow throughout the entire chain.
Okay, no guaranteed payments, easy deductions, anything else?
Yes, and perhaps most critically, there was no common law right for a contractor to suspend work for non-payment. Cases like Canterbury Pipelines here confirm this. So even when they weren't being paid, contractors were often forced to keep working, pouring more resources in, increasing their exposure. It was a vicious cycle.
It sounds like a house of cards, really. Was there anything in place before then that offered some protection, maybe for workers or subcontractors?
There was, but unfortunately it had been removed years earlier. There used to be some measure of comfort from Section 21 of the Wage Earners Protection and Contractors Lands Act in 1939. This act allowed any contractor, subcontractor, or even a worker to claim a lien over the land for unpaid work.
A lien. So a legal claim on the actual property.
Exactly. In practical terms, it meant anyone buying land or their lawyers had a real interest in ensuring the seller had paid for all the work done on the property. It offered a crucial layer of protection. It made it harder to sell or transfer until the builders were paid. But that vital legislation was repealed back in 1987, creating a significant void in protection, just as the industry was getting more complex and project values were soaring. So when the CCA arrived in 2002, it was stepping into a gaping hole with really ambitious goals: facilitate regular, timely payments, provide speedy dispute resolution, and offer effective remedies for recovery.
And was New Zealand going it alone here, or were other countries grappling with similar problems? Did we look overseas?
Oh, definitely. New Zealand's legislation was absolutely influenced by similar things happening abroad, particularly in the UK and New South Wales, Australia. The UK construction industry, for instance, had been publicly described as dysfunctional in a, well, pretty scathing 1994 government review.
So functional, that's strong language.
It was, and it led to Sir Michael Latham's incredibly influential Constructing the Team report. It didn't pull any punches. It recommended a wholesale increase in cooperation, a new approach to contracting, and critically streamlined dispute resolution. A direct result was the UK's Housing Grants, Construction and Regeneration Act 1996, which introduced statutory adjudication, a key precursor to what we adopted.
Right, so the UK paved the way with adjudication.
They did, and New South Wales and Australia followed suit with its own security of payment legislation in the very same year. So New Zealand was very much part of a global movement, learning from others grappling with these same endemic issues in their construction sectors.
So the CCA was born from urgent need, bolstered by international examples, driven by bold aspirations. But now, looking back over more than 2 decades, how is it actually measured up? Are we still seeing those kinds of devastating company failures?
That's a really critical question, and the answer is, well, complex. While the acts certainly had bold and necessary goals, the unfortunate reality is we have seen ongoing firm failures even since it passed. Maine Zeal, for instance, collapsed a full 10 years after the act was implemented.
Right, that was a big one, even with the act in place.
It was, and it highlights a persistent fundamental challenge, particularly when it comes to securing payment effectively down the entire contractual chain. It's worth remembering the general policy statement with the bill in 2001 explicitly noted payments are typically in arrears. It warned that head contractors with cash flow problems might deliberately delay payments, using those down the chain to effectively self-finance projects. It even presciently warned of head contractors withholding or diverting payments and the devastating consequences for subs if the head contractor failed.
So the problem was known right from the start.
It was clearly identified. And it's deeply unfortunate that this very issue, highlighted at the Act's inception, has, in the eyes of many commentators, never been fully addressed by the Act or its later amendments. The failure to adequately protect all tiers of the supply chain, it remains a significant concern, a persistent crack in the Act's otherwise strong facade.
That's a powerful point about persistent challenges. So, okay, for our listeners, maybe a contractor, a principal, even a homeowner starting a renovation, how does this act actually work day to day? Let's walk through the practical steps, the nuts and bolts of the payment claim and adjudication process. It sounds like there are very specific rules you have to follow.
You're absolutely right. The CCA establishes a very clear, almost choreographed sequence of actions. It's designed precisely to ensure those timely payments and prevent those historical cash flow problems. And yes, it is highly prescriptive. Missing even a single step can have significant, often those sudden death consequences.
Okay, so if I'm a contractor, I've just finished a stage of work. What's my very first move under the CCA?
Your initial and crucial step as the payee, whether you're a head contractor, a subbie, or even consultant, is to issue what the Act specifically calls a payment claim. This isn't just any old invoice. It has to meet extremely strict requirements to be valid under the CCA. For example, it must be in writing. It needs very specific details. You have to clearly identify the particular construction contract it relates to, specify the exact work and the period covered, state the precise amount you're claiming, and the exact due date for payment.
So really itemized and clear.
Absolutely. And crucially, you need to explain how that amount was calculated, maybe attach a detailed spreadsheet, schedule of rates, breakdown of costs, and this is perhaps the most vital bit. The document must explicitly state that it is a payment claim made under the Construction Contracts Act 2002, and it absolutely must be accompanied by certain prescribed information, usually a standard form notice from the regulations. Without that explicit statement, and the form is just an invoice, not a CCA payment claim, and the Act's powerful mechanisms don't apply.
Got it. Specific document, clearly labeled, detailed breakdown, not just a generic bill. And how often are these claims usually issued? Is there a rhythm?
Typically, they're issued monthly, mirroring the usual progress payment cycles, though a contract can specify something different. It's also important that a claim issued too late might not be valid for that period, meaning those powerful legal pressure mechanisms won't be available until the next valid claim, maybe a month later. Now, here's where the rubber really meets the road for the payer. If they fail to pay the full claimed amount or fail to issue a proper payment schedule in response within the strict time frame, then the full amount stated in your payment claim is legally treated as a debt due and can be immediately enforced in court. That's that sudden death aspect for the payer we talked about. It's an incredibly powerful deterrent.
Wow, okay. That puts a huge onus on the payer to respond properly. So once a payer gets one of these very specific, legally potent payment claims, what are their options? What do they have to do?
Right. Upon receiving a valid payment claim, the payer has very limited options, and again, operates under incredibly strict timeframes, typically 20 working days from the claim date, unless the contract says otherwise. Their choices are pretty straightforward. 1, pay the full claimed amount by the due date, or 2, if they genuinely dispute the amount, they can issue what's called a payment schedule.
A payment schedule. Okay, what does that involve?
A payment schedule lets them propose paying a lesser amount, which sometimes can even be $0. But it's absolutely not enough to just state a lower amount. The payment schedule itself has to meet strict requirements too. It must be in writing, identify the related payment claim, state the proposed payment amount, and crucially, if that scheduled amount is less than the claimed amount, it must detail how the scheduled amount was calculated. It must clearly explain the reasons for the difference and provide specific reasons for withholding payment.
Specific reasons. So they can't just say, I don't agree.
Exactly. They can't just say, I don't agree, or the work's defective. They have to justify why they're withholding funds with specific actionable reasons. It forces transparency.
So if I'm a payer, I can't just ignore it or send back a vague refusal. I have to provide a detailed, reasoned response. What happens if I fail to do that? Or if I issue a payment schedule but then don't actually pay the amount I said I would?
Good question. If a payer issues a payment schedule but then fails to pay the scheduled amount, or even worse, does absolutely nothing in response to a valid payment claim, the payee gets incredibly powerful remedies under the Act. They can, for instance, legally suspend work on the project, just stop everything until payment's made. They can also immediately initiate statutory adjudication proceedings, or they can just commence a court action for the debt. This suite of remedies powerfully reinforces that pay now, argue later principle, provides immediate severe consequences for noncompliance. It's all about keeping that cash flowing.
That leads us right to the heart of the Act. Adjudication itself. Can you explain what adjudication is, who the adjudicator is, and why this mechanism is such a central, almost revolutionary part of the CCA?
Yeah, adjudication is a truly unique statutory dispute resolution procedure. It's purpose-built for the fast-paced world of construction. It involves an independent third party, the adjudicator, who is appointed to make an interim decision on a dispute. The emphasis on interim is key.
Interim, right, not final.
Exactly. It's specifically designed to be significantly quicker and far less formal than traditional court proceedings or even arbitration. We're often talking about a process yielding a decision in as little as 5 to 7 weeks, start to finish, which is a massive contrast to the months or even years litigation can take. The adjudicator is typically a highly experienced professional, often a lawyer, engineer, quantity surveyor with deep expertise in construction law and industry practices. They can grasp complex technical issues quickly.
So it's fast, and the adjudicator's decision is binding in the interim, but not final. That's a really important distinction, isn't it? Keeps the immediate flow going, but doesn't shut the door on deeper arguments.
It is the distinction that makes the CCA so uniquely powerful. An adjudicator's decision is indeed binding in the interim, meaning the losing party must pay the amount awarded. If you owe money after a decision, you have to pay it. You can't just ignore it. However, and this is the crucial part, it's not the ultimate final word on the dispute. The losing party keeps the right to pursue the merits of the dispute for a final determination in a different forum, like arbitration or the High Court.
Okay, so it separates the immediate need for cash from the longer fight over who is ultimately right.
Precisely. It ensures cash flow continues, projects aren't stalled by disputes, work progresses. While any longer-term legal battles over the ultimate merits or final figures can still play out, the immediate financial obligation is clear and enforceable. Keeps money flowing, work progressing, even when there are serious disagreements.
That's quite comprehensive. So, beyond just being binding but interim, what are the other key benefits of using adjudication over, say, going to court, which would be so long and expensive?
Well, there are several key benefits that make adjudication highly preferred, especially given the speed of construction projects. Firstly, as we've said, its timeliness is paramount, 3 to 6 months typically versus potentially years for litigation. Huge advantage. Secondly, it's generally far more cost-effective. Because of those tight timeframes and the less formal process, legal and expert costs are more predictable and usually significantly less than traditional routes.
And you mentioned expertise.
Yes. Thirdly, the benefit of expertise. Adjudicators aren't just general legal pros. They often have deep, specialized expertise in construction law or industry practice. They genuinely understand the technical nuances, building techniques, quantity surveying, whatever it is. Parties often get to agree on an adjudicator, ensuring someone with the right expertise is chosen. If they can't agree, an authorized nominating authority, like the Building Disputes Tribunal, appoints one from a pre-approved panel, ensures impartiality and competence. So decisions are usually well-informed and practical.
It sounds like a very structured, almost clinical process, given those tight timelines. Can you elaborate on the specific rules? Are those timeframes really that strict? Seems counterintuitive for legal processes.
Oh, they are indeed that strict. The adjudication process is highly prescriptive, with mandatory, very unforgiving timeframes. Failure to meet these deadlines can be fatal to a claim or a defense. Your argument might be dismissed just because you missed a filing deadline.
Fatal, wow.
Yeah. For example, a claimant often needs to meticulously prepare their entire case evidence, arguments, everything, before even serving the notice of adjudication. Because once that notice is served, the clock starts ticking furiously for every single subsequent step. You can't gather your evidence later. It needs to be ready to go.
And how are adjudicators appointed? What about their fees? Is that another cost layer?
Parties can try to agree on an adjudicator. Claimant often proposes a list. If no agreement, an authorized nominating authority appoints one from their panel. Regarding fees, yes, adjudicators are independent professionals. They typically require security for their fees up front before they even accept the appointment or issue their determination. It's standard practice, ensures they get paid for their work regardless of the outcome. It's a cost, but often far more predictable and contained than prolonged litigation.
What if the party responding, wants to bring up their own claims? Say they think the claimant owes them money, can they just chuck that into their response?
A crucial point and a common misunderstanding. A respondent cannot raise a counterclaim in their response to an adjudication claim.
Really? So what do?
If they have their own claim, they must initiate a separate adjudication process entirely. Now, the Act does allow adjudicators, with everyone's consent, to hear related proceedings concurrently. But this requires incredibly rapid action from the respondent to start their own adjudication almost immediately after getting the first one. It keeps the initial adjudication focused.
Seems like it could get complicated with multiple adjudications. What about the adjudicator's own authority? Can they decide if they even have the power to hear a dispute?
Yes, absolutely. An adjudicator has the power to determine their own jurisdiction. They can even deal with this as a preliminary issue, which can save costs if there's a genuine challenge, like, is there even a valid contract? Is the claim against the right party? It's a vital safeguard.
And the documents submitted, are there strict legal forms or rules of evidence like in court? That sounds like it could slow things down.
Thankfully, no, not in the same rigid way. While the initial notice has prescribed info, there aren't specific legal forms for the main adjudication documents: the claim, response, reply, rejoinder. In practice, they usually involve detailed factual evidence, expert evidence, engineers, surveyors, legal arguments, and bundles of supporting documents. Critically, the formal rules of evidence that apply in court do not apply in adjudication. This allows for a more flexible, less formal, and significantly faster process, which is exactly the point.
Finally, after all this, what kind of relief can an adjudicator actually provide? What can the successful party expect to get?
Adjudicators can award either monetary relief or declaratory relief. Monetary relief is, money owed, damages, amounts due under the statute. Declaratory relief involves formal declarations about rights and obligations under the contract, like interpreting a clause. A particularly significant benefit, especially for claimants, is the ability to seek a charging order over the construction site itself, if the respondent owns it.
A charging order, what's that exactly?
Think of it like putting a legal claim or sort of mortgage on the property itself. It's a powerful form of security over the land, making it difficult for the owner to sell or transfer the property until the debt is paid. This is a key advantage over other dispute mechanisms, where getting such an order usually happens much later, after a judgment. It gives the successful party real leverage right from the start.
Okay, so an adjudicator's decision is made, an amount's due, it's binding in the interim. But what if someone really, really disagrees? Can they just challenge it in court? Are there limits? And then critically, what about actually getting paid? Getting a determination is one thing, getting the cash is another.
You've absolutely hit on where the true test of the act lies. While the determination is binding in the interim, judicial review has unfortunately been strategically used by some parties as a tactic to delay or even try to outright avoid payment of adjudication awards. It's a direct attempt to bypass that crucial pay now, argue later policy.
So the courts know this happens. Do they just let parties use judicial review to stall and undermine the act?
No, absolutely not. Courts are incredibly cautious about intervening. They are vigilant and consistently ensure judicial review does not undermine the core scheme and objectives of the CCA, specifically that swift payment policy. The legal bar for succeeding in judicial review is extraordinarily high. To succeed, a party generally needs to show very limited and serious grounds, like a genuine excess of jurisdiction by the adjudicator. They ruled on something they simply weren't legally allowed to. Or a serious breach of natural justice, maybe not given a fair chance to present their case, or clear bias from the adjudicator. Or perhaps some apparent and significant error of law that just jumps out from the decision itself. It's about the process and authority, not re-arguing the facts.
So it's not about whether the adjudicator got the facts right or wrong, but more about whether they followed the rules and stayed within their legal boundaries. That's a key distinction.
Exactly. Courts consistently reinforce that pay now, argue later principle. They strongly urge dissatisfied parties, pay the required amount first, then use the other CCA methods, litigation, arbitration, mediation, to challenge the merits later. They see adjudication as that rough and ready interim determination for speed and cash flow, not a perfect final judgment. There's a notable case, Body Corporate 2012 v. Keenan Orrs. A body corporate tried judicial review to avoid paying Naylor Love millions for a leaky building remediation, pending a much longer arbitration. The High Court decisively dismissed it. Reinforced pay now, argue later, stated contractual interpretation is outside judicial review's narrow scope. Naylor Love got paid. The court's message was clear. Pay first, argue specifics later in the proper forum.
That clarifies judicial review. But then there's actually getting the money. How effective is the act at ensuring payment happens, especially if someone's determined to avoid it?
This is where things get complex and sometimes regrettably inconsistent, which creates uncertainty. Payments due under the Act from ignored claims, unpaid schedules, or adjudication determinations can be pursued through court actions, including bankruptcy proceedings, statutory demands. Critically, in these specific debt recovery proceedings, the court cannot give effect to counterclaims or set-offs, meaning the CCA debt stands as a pure debt. You can't try to chip away at it by raising other unrelated claims in that specific enforcement action.
So the idea is to keep enforcement clean, focused only on getting the determined money paid. But you mentioned inconsistencies. That sounds like a vulnerability.
Yes, this has been a significant point of contention. The Court of Appeal in the big 2009 Laywood and Reese case clearly affirmed that bankruptcy and statutory demands are legitimate means for recovering adjudication awards, and that an adjudicator's determination is final for Insolvency Act purposes. The court's reasoning was sound. Allowing parties to resist payment with counterclaims in these contexts would fundamentally undermine the Act's purpose, recreating the cash flow problems it aimed to solve.
Okay, that seems clear enough from the top court.
You think so? But unfortunately, there have been subsequent cases, like Concrete Structures v. NMHB and Cary-Eady v. Donovan Drainage and Earth Moving, where lower courts have allowed judgment debtors to raise counterclaims in bankruptcy proceedings, effectively treating adjudicator determinations as non-final in that specific context. This creates a significant and problematic inconsistency. If it's not corrected or clarified higher up, it seriously risks undermining the Act's fundamental pay now, argue later purpose. creates uncertainty where clarity is needed.
That sounds like a critical loophole, a real problem. Does this judicial inconsistency mean that even if you win an adjudication, go through all that, you might still struggle to actually get paid?
Unfortunately, yes, that can be the stark reality. The Marsden Villas litigation is a particularly sobering example. The contractor, Leywood Construction, won through 2 separate adjudications, faced judicial review, appealed all the way to the Court of Appeal, a multi-year legal marathon. Despite winning decisively everywhere, having clear determinations, they still failed to get paid by the principal. Bankruptcy and statutory demands were their only remaining and ultimately unsuccessful recourse. It vividly illustrates the real enforcement challenge. Even with a clear, binding determination, recovering the money can become an arduous, frustrating battle if the payer is determined to resist.
That's truly sobering. Is there any way for a payer to legally resist enforcement beyond those very limited judicial review grounds? What if they genuinely think the adjudicator made a massive error?
It's exceedingly difficult, but not entirely impossible. A payer can potentially resist enforcement by initiating judicial review and simultaneously seeking an interim court order temporarily excusing payment. But this is an exceptionally high bar. As seen in Shundy Customs Limited v. Green, they need to show not just a serious question about the decision's validity beyond just disagreeing, but also prove irreparable prejudice if payment is immediately enforced. The court also weighs prejudice to the payee if they don't get paid. It's a fine balance. Another more drastic, complex strategy is voluntary administration under the Companies Act. This can give a company a statutory moratorium, a breathing space against enforcement, allowing a chance to restructure while disputes are resolved. But again, complex with its own consequences.
The construction landscape is always evolving, and so, it seems, must the laws. How has the Act itself been updated since 2002? And maybe more importantly, what are the lingering issues or areas for improvement still needed to truly fulfill its original promise?
The Act has certainly evolved, trying to adapt. There were significant 2015 amendments aimed at strengthening it and addressing initial shortcomings. For instance, the definition of a construction contract was broadened. It now explicitly includes design, engineering, and quantity surveying services. That was crucial because, before 2015, disputes over these essential services might not have clearly fallen under the Act's speedy adjudication, leaving architects, engineers, QSs in a bit of a gray area. Bringing them in ensured more comprehensive coverage.
Okay, wider scope. What else?
Also, the previously unhelpful distinctions between residential and commercial contracts were removed. Simplified things, prevented arguments over contract type. Adjudication procedures themselves were clarified, refined, easing response times, adding rights of reply and rejoinder, making it fairer, more robust. And a hugely significant addition was establishing a statutory trust for retention monies.
Ah, yes, retention money. That's always a big one. Was that 2015 change effective enough, or did issues persist, leading to more changes?
While 2015 was a vital step, issues around retentions unfortunately did persist. The problem often stemmed from contractors treating retention money withheld as security, as their own working capital. It got commingled with other funds, sometimes diverted, so when a company collapsed, the retention money just wasn't there for the subcontractors. This led to the 2023 Retention Money Amendment Act, effective October 2023, which significantly strengthened the rules.
Okay, so what did the 2023 changes do specifically?
Now, under the 2023 Act, retention money automatically becomes trust money the moment it's retained. No ambiguity. The Act now strictly mandates how this trust money must be held, either as cash in a dedicated NZ bank account just for retentions, or by a complying instrument like an insurance bond or bank guarantee. Crucially, it explicitly cannot be commingled with other non-trust funds. This directly tackles that past problem of companies using retentions as working capital.
So it's really about ring-fencing that money, protecting it. Are there other safeguards, penalties?
Yes. Party A, the payer holding the retentions, must provide regular specific info about it to Party B, the payee whose money it is. They also have to keep meticulous accounting records, available on request. And the penalties are now substantial. Fines of $200,000 for failing to hold money on trust. But perhaps most notably, it introduced director liability for failures, with very limited defenses. Directors can be personally accountable if their company breaches these rules. Powerful incentive.
Director liability, that's significant. But even with these stronger rules, is it enough? Does it solve the whole payment security problem down the chain?
That's the debate. Despite these enhanced retention provisions, some commentators still suggest they might not fully protect subcontractors from massive shortfalls like in Mainzeal. The issue there was broader than just retentions. It was the fundamental flow of all progress payments. So while a big step forward, the focus solely on retentions is seen by some as still not fully addressing the larger systemic problem of securing all progress payments down the entire contractual chain.
That's critical. So despite amendments and good intent, you're saying there are still fundamental, unaddressed issues preventing the act reaching its full potential, especially for subcontractors. What are these biggest failings?
That's right. One of the biggest failings, consistently identified, is that the Act doesn't fully recognize that payment disputes on big projects are inherently deeply interlinked throughout the whole supply chain. Adjudication determinations are, by design, contract-specific, meaning a payment determination for a head contractor brings no direct benefit or liability to subcontractors further down. Imagine an owner pays a head contractor. That head contractor is adjudicated, owing money to their subbie. If the head contractor then collapses, the subbie is still largely exposed, even though the money theoretically flowed to the head contractor.
So this perpetuates what some call that Ponzi scheme problem, where the head contractor relies on owner payments to pay lower tiers, but if payments are delayed or diverted, the structure crumbles, hitting the subcontractors.
Precisely. It perpetuates that historical issue. Head contractors might withhold or divert payments meant for subs, using their work and cash flow to finance their own operations. Leaves subs dangerously exposed if the head contractor fails. Even if an owner makes substantial progress payments, often very little is retained by the head contractor. Most is quickly due to the subs and suppliers doing the actual work that benefits the owner. The current act doesn't adequately compel that flow through.
Sounds like a significant systemic issue. So what are the concrete recommendations? How could adjudication itself be improved? Or, more broadly, how can we better address this supply chain payment issue beyond just retentions?
Absolutely. For improving adjudication specifically, several recommendations emerge. Firstly, encourage parties to define issues narrowly, clearly from the start. Avoid those overly broad declarations of war in dispute notices. Secondly, encourage parties to agree on adjudicators. Leveraging the small pool of experienced pros can lead to better, more durable decisions. Trust is higher. Thirdly, allow adjudicators and counsel more flexibility to refine procedures case by case rather than rigid adherence to one-size-fits-all. Fourth, refine submissions to address only specific issues properly. Avoid unnecessary bulk. Fifth, promote using experts on a common basis input from both parties and the adjudicator. More collaborative, efficient. Sixth, ensure costs are proportionate and discuss transparently with clients up front. And finally, maybe consider formal mentoring for adjudicators, even peer review of determinations. Possibly publication of anonymized decisions, they often become public anyway during enforcement. Could enhance transparency, consistency.
Those are great recommendations for the adjudication process itself. But back to that Ponzi scheme problem, securing payment for subcontractors down the chain. Are there concrete proposals beyond the current act to truly fix that?
Yes, various approaches are being suggested without necessarily reintroducing old lien acts or imposing statutory trusts on every payment, which is complex. One prominent idea is legally requiring contractual disbursement. Contracts would include clauses ensuring progress payments to head contractors are properly, swiftly dispersed to their subs and suppliers.
How would that work in practice?
Could be several ways. Maybe requiring subcontracts be registered with owners, demanding proof of payment to subs, or allowing direct payment from owner to subs if the head contractor defaults. Actually, project funders are increasingly starting to require this kind of transparency and direct flow anyway. They see it as good risk management.
Interesting. Other ideas?
Second proposal. Allow subcontractors to join head contract adjudications to get direct payment orders from amounts determined due to the head contractor. Give subs direct access to funds owed for their work. And a third, more radical idea. Make owners directly liable for amounts determined due to subcontractors from head contractors in adjudication. These proposals aim to significantly increase the incentive for owners and financiers to ensure full compliance down the chain, recognizing their interest in ensuring the subs who do most of the work get paid. Without explicitly recognizing subcontractors' interests in project cash flow, many suggest the act, as is, won't reach its full potential in securing payment for everyone.
So what does all this mean for you, our listener? Whether you're a seasoned player immersed in construction or simply someone trying to grasp the legal scaffolding beneath this vital sector. Well, the Construction Contracts Act 2002, with its foundational pay now, argue later principle, has undeniably delivered significant successes. It's demonstrably helped secure more timely payments, at least at the head contractor level, sweeping away those problematic pay when paid clauses. And statutory adjudication generally provides a remarkably swift and effective dispute resolution mechanism compared to the often glacial pace of traditional courts. However, as we've explored today, it still faces significant, deep-seated challenges. The most critical, in many eyes, is that persistent struggle to secure payment effectively down the entire contractual chain, ensuring the subcontractors don't bear undue, crushing financial risk. There's also the ongoing issue of consistent enforcement, particularly in insolvency, where judicial interpretations have sometimes created uncertainty, leaving successful parties in limbo. Despite these hurdles, the pay now, argue later principle remains the persistent, powerful, and absolutely vital core of the Act, continually pushing to keep cash flow alive. And for a final, provocative thought to leave you with, commentaries often suggest that while the Act provides powerful legal tools, perhaps the biggest shift needed isn't just in legislation, but in the entire industry's mindset and procurement practices. Moving from risk transfer to true risk allocation, acknowledging the reality of how projects are actually built rather than an idealized fantasy. What does this fundamental shift truly require from everyone involved, from government to the smallest subcontractor? It's a question for the industry, really.
And if we connect this to the bigger picture, it raises that important question. Is the Act falling short because of its design, or because the underlying industry practices it aims to regulate are still fundamentally misaligned with its aspirational goals of fairness and consistent cash flow?
Before you go, please don't forget to share, like, or subscribe to our deep dive series. Also, make sure to visit the CM Guide website for even better insights on this crucial topic and to explore our other episodes.